Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are all based on a sliding scale based on your income, which means the less you make, the less you pay. Today, I want to talk to you about something called a harassment prevention order. Although technically, a harassment prevention order is not a criminal matter as far as obtaining the order, a violation of that order is a criminal charge, can be a criminal charge. So, what is a harassment prevention order? Well, it's similar to a restraining order. A restraining order and a harassment order, if they're accepted by the court, if they're issued by the court, it stops somebody else from engaging in certain activities. So, typically, restraining orders or harassment prevention orders can be issued to keep somebody away from you, not be able to have contact with you, not harass you, not visit you at your home or your workplace of work, or things along that line. One of the differences is a restraining order under Section 209A is for people who are have a special relationship to one another, typically a significant dating relationship. A harassment prevention order can apply to anybody. There doesn't have to be any special relationship between the parties, the plaintiff and the defendant. And just to be clear, the plaintiff is the person who's asking for the order, and the defendant is the person against whom the order is being sought. And oftentimes that person wants to fight having the issuance of the order. So the process is basically the same for both. The plaintiff goes into the court, fills out some paperwork, including an affidavit, which is a sworn statement, and then laying out exactly what the allegations are. And in the harassment prevention order, they must show that there are three separate incidents of harassing behavior. They file that with the court, and on that day, they will go before the judge for what they call an ex parte hearing. That just means there's one party, only one party, the plaintiff. And if the judge is satisfied that an order should be in place temporarily, that order is put into place. Within a short period of time, 10 days, there has to be a two-party hearing. So it's at that point the order goes into place, and that order must be served upon the defendant. They have to be given notice that their freedom is curtailed, at least to a certain point, in that they can't engage in activities such as contacting you. They will also be notified of the court date for the two-party hearing in case they want to attend and participate in that hearing. One of the questions that comes up often is, are words, mere words, can that amount to harassing behavior? And the general rule is no. Words alone cannot give rise to a harassment prevention order, or words are not harassing in a particular sense. Whereby, if you have three incidents, it would support an order of harassment prevention. People's free speech obviously is protected by the First Amendment to the U.S. Constitution. We're basically allowed to say what we want about anything we want within certain parameters. It's not absolute. And in this particular situation, the courts in Massachusetts have said that the anything that would have to qualify for a harassment prevention order, if it's mere speech, has to fall outside of the protections of the First Amendment. So the general rules is that your speech is protected under the First Amendment, but there are certain specific categories of speech which can be considered harassing. And there are two, and those two are fighting words and true threats. And these two things are specific under the case law. So true threats means a certain thing under the law, not necessarily what you might think of in normal conversation. So I'd like to read to you some of the couple of these definitions that the case law has come up with. So for fighting words are limited to face-to-face personal insults directed to the person of the hearer, inherently likely to provoke a violent interaction. So you have to be in person, basically face to face with that person, and your language is such that it provokes or is likely to provoke that other person to lash out physically at you. Um, that's what fighting words are. So it has to be directed at the person. Sometimes uh, mere offensive language can be directed or be referring to a person, but it has to be directed at that person, basically face to face in a certain situation. There is a case, which is one of the most important cases on this issue, where there was a landlord that was trying to evict two of her tenants. When she went into the place that was being rented, she heard that one of the tenants was on the phone, and they had been having problems all along. And that person was on the phone using very offensive language, referring to the landlord, to whoever he was talking to on the phone. And that went on for some time, and it was very loud, and it was very offensive language. The use of certain words were present, and the landlord took offense to that. But the court said it wasn't directed at her. She merely heard it, and it wasn't anything that was going to provoke her to lash out in a physical manner. And again, it wasn't directed at her, so that was not considered. Those were not considered fighting words. So a harassment prevention order should not have been based on that being one of the three harassing incidents. The other definition is true threats. True threats are serious expressions of an intent to commit an act of unlawful violence. So it's not just something like, oh, I could, kick that person, or I could, I'd like to punch him or something like that. It's something that's really very imminent, and it's threatening to the other person, and the intent of the person who is speaking these words is to put that person in fear, and the other person is in fact put into fear of very violent behavior. So it's not just I could kill that guy. It's got to be something very specific and very threatening. So those are the two general categories that can be considered, that free speech does not apply to, and those things can be considered in a harassment prevention order. So, as I say, at Afford Law, we do practice criminal and family law throughout Massachusetts. Our fees are based on your income, so the less you make, the less you have to pay. Feel free to visit us at affordlaw.org, and please feel free to book a free virtual appointment with me. I would be happy to answer any questions you might have about any criminal law or family law questions in Massachusetts. Because at Afford Law, we're making justice affordable.